Hello, good morning students. Please subscribe the channel, drop a like, share and comment. This is Shree Vishnu Art Press Publications, exercise number 1 and 2 on the speed of 90 words per minute. Start. Per contra, Mr. Y. Datta, learned additional Solicitor General, submitted that the placement in selection grade is not by virtue of length of service alone, but certain mandatory conditions under the career advancement scheme, and that the case of the appellant for placement in senior scale selection grade reader was examined by the screening committee, and since he could not satisfy the mandatory requirements, his name was not considered. Our attention was also drawn to certain averments made in the counter affidavit filed in this court on merits of the claim made by the appellant for reviewing the order of the division bench. He denied that the screening committee was neither malified nor biased, and it adhered to career advancement scheme as laid down by UGC and the Ministry of Human Resources Development, and that the appellant did not fulfill the mandatory and statutory conditions for the award of senior skill. It was submitted that the scope of application for review is more restricted than that of an appeal, and therefore the review application has no merits. We are unable to countenance the argument advanced by learned additional Solicitor General appearing for the respondents. A careful perusal of the impugned judgment does not deal with and decide many important issues, as could be seen from the grounds of review and as raised in the grounds of special leave petition or appeal. The High Court, in our opinion, is not justified in ignoring the materials on record which, on proper consideration, may justify the claim of the appellant. Learned counsel for the appellant has also explained to this court as to why the appellant could not place before the division bench some of these documents which were not in possession of the appellant at the time of hearing of the case. The High Court, in our opinion, is not correct in overlooking the documents relied on by the appellant and the respondents. In our opinion, review jurisdiction is available in the present case, since the impugned judgment is a clear case of an error apparent on the face of the record and non-consideration of relevant documents. The appellant, in our opinion, has got a strong case in their favor, and if the claim of the appellant in this appeal is not countenanced, the appellant will suffer immeasurable loss and injury. Law is well settled that the power of judicial review of its own order by the High Court inheres in every court of plenary jurisdiction to prevent miscarriage of justice. The submission of Sri Arvind Srivastava, learned counsel for the petitioner, is in three folds. Firstly, that the order dated 1/8/2002, by which the term of the Committee of Management has been accepted to be 5 years instead of 3 years, was challenged by the petitioner by filing a representation on 18/6/2003, and as such, without deciding the said representation, the term of the Committee of Management could not be held to be 5 years, and it ought to have been treated as ended after 3 years. It is secondly contended by Sri Arvind Srivastava that recognition given to the election held in the year 2005 was not in terms of the government order dated 19/12/2000, and thus the impugned order is liable to be set aside. Lastly, it is submitted that the petitioners held parallel election in the year 2003 and 2006, on which no orders were passed by the Joint Director of Education, and papers have been returned to the Society or Committee of Management, and without the same having been resolved, no decision could have been taken with regard to the election held by the respondent number 5 in May 2005. The first submission of learned counsel for the petitioner has no force in view of the fact that the Joint Director of Education wide order dated 8/1/2004 has accepted that the term of the Committee of Management is 5 years. The same has also been confirmed by the writ court by the judgment and order dated 28/1/2004, passed in writ petition number 2472 of 2004, against which the appeal of the petitioner has also been dismissed. As regards the second contention, no material irregularity has been pointed out by the petitioner with regard to the election of the Committee of Management. Further, what is submitted is that the respondent number 5, the manager of Committee of Management, is not even a member of the society, and as such he is a trespasser and not entitled to be elected as manager or hold the election of the Committee of Management. It is also submitted that the date of election as contended by the respondent number 5 was 21/5/2005, whereas the Joint Director of Education has held that the election was held on 8/5/2005, which was duly recognized by the Regional Committee on 20/5/2005. In my view, these are disputed questions of fact that as to whether the elections were held on a particular date or not, and whether the respondent number 5 is the member of the society or not, which cannot be decided in writ jurisdiction, as evidence would have to be adduced by the parties for deciding such issues. The petitioner was earlier also given an opportunity by the writ court to file a civil suit, and the division bench also, after relying the full bench decision of this court, has held that civil suit would be the appropriate remedy. The petitioner has chosen not to approach the civil court but has again come up in writ jurisdiction, which is not the proper forum for deciding such issues.